Towards school straight, then take a turn, then
This stuff towards school road, but this other road now.
other road. Okay. You take while taking a turn.
Yes, yes.
One hill.
Yeah, one
for going down.
Morning, Your Lordship. This is mentioned actually for the listing of criminal misapplication. It's a little urgent because the date of surrender is tomorrow. Your Lordship was pleased to grant him 2 months interim bail to the accused. The date of surrender is tomorrow, Your Lordship. Because of supervening circumstances, it is necessary for it to be extended. I'll please.
But why you should have filed the application well in time?
Sir, I'll let you know when during the course of the hearing. It came to my notice only yesterday. Certain facts and circumstances, Your Lordship. It's in regards to treatment, that is why.
Have you filed the application?
I already have, sir. I've also served a copy.
Fine.
Lord, item 8. My Lord, the record I have received, my Lord. My Lord, this is that full bid of the school teachers. My Lord, there are a lot of
teacher matter.
My Lord. So, my Lord, I have to go through the record also. My Lord, not flag mark for convenience of the court. My Lord, and today I have some difficulty. May the matter be listed on Friday, my Lord?
Friday.
Today is Tuesday. Oblige, my Lord.
On pre-made by Mr. P. Varsari, Leonard G. Not objected to by petitioner. This is matter on Friday.
Friday. Oblige, my
Deeply obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7, Your Lordship. I've informed the counsel for your side, Your Lordship.
This is that
compensation bill, Your Lordship.
Electricity matter. How long?
After vacation, Your Lordship.
On pre-made by the petitioner, not objected to by respondent. Matter is adjourned. Yes,
Hello, I'm appearing for this one. Yes. Corporation, my lord. Responding
he sought,
corporation.
he said he has sought your consent for
My lord, yes, yes. My friend has already spoken to me.
so after vacation
My lord.
as agreed to by the parties. This is matter after vacation.
May it please your lordship, I beg to make a mention of item number 3. Lordship, 3 and 4 are connected matters, lordship.
What are these matters about?
It's regularization of services. Lordship, I humbly pray this matter may be listed after vacations.
On pre-made by petitioner, not objected to by respondents. Matters adjourned. As agreed to, list this matter after vacation.
Highly obliged, lordship.
So that's 3 and 4.
3 and 4 connected, yes, Your Lordship.
From the list, item number 1.
Your Lordship, in this case, I am filing my affidavit in the during course of the day.
Lordship, I am appealing for document 1 number 3.
You have already filed your. You may want to file a rejoinder. Are you filing any rejoinder? You have not received copy.
I'm receiving it right now, my lord. We'll need to examine this and then we'll come back with instructions. Your Lord.
Mr. R. Debra Leonard, CGC has submitted that the counter affidavit may be allowed to be filed in course of the day. Leonard counsel for the petitioner, Mr. Leonard counsel for the petitioner has submitted that on receipt of the copy of the said counter affidavit, the petitioner may be allowed to produce the same and to apprise this court as to whether the rejoinder is required to be filed. As prayed for, this is matter up to 2 weeks.
And submit.
Item number 2.
May I please, Your Lordship, I have filed the objection, so matter may be come up after a week, my lord, for hearing of this condolation of delay.
Why would you object?
563 days, my lord. 563 days delay.
The award is in your favor.
Yes, sir.
It's a very substantial award, 28 lakhs odd, and good grounds of appeal are there. Delay, I know, is slightly on the higher side, but my lord, the case is such, the merits of the appeal itself is such. Lordship, may kindly condone the delay. Matter can be decided on merits, my lord, and we are only on the quantum, no other ground, no other technical grounds, etc. Just on the quantum, our contention in our appeal is that
If it's an issue of quantum,
yes, my
then you could have negotiated with the party for a amicable settlement.
Settlement in the sense our contention is that the quantum which has been awarded on the basis of a judgment of the Supreme Court, Pranay Sethi, 2015 judgment. Lordship, that's the standard calculation that is conducted. Our contention is Pranay Sethi has been completely misapplied for the reason that there is absolutely no proof of age. Pranay Sethi's entire calculations of future prospects, etc., is based on what is the age of the deceased.
Anyway, that's beside the point.
Yes, my lord. Yes,
If you are not on those technicalities,
yes, my lord.
except on the quantum that has been awarded,
Yes, my lord.
and the respondent,
Yes, my lord.
or the claimant for that matter,
Yes, my lord.
if they are agreeable, then you see that matter can be worked out. Why don't you get instruction from your client? If at all, the quantum is a bit on the higher side,
Yes,
you should settle for something less, like in a local adalat, and come back with it. Otherwise we have to go through this whole process of the appeal being heard, decided on merits. It might go up, it might not go up, we don't know.
yes,
Finally, who will be the loser?
yes.
because as it is, everything has to be taken into consideration. It's an accident of which year?
2012, my lord.
2012.
Yes, my lord, it is a long pending case.
And Mr. General, if that is the case, beside the quantum, I don't know what is the principal amount.
Yes,
but then you have also to think of the interest, considering the cost of living and the inflation and all those things.
True, my lord.
So keep that in mind.
Yes,
I would urge upon the parties to try to settle this matter.
Very well. If I can request,
the two of you can work it out. Get your clients to sit across the table. Decide, and then come back on the next day with some positive, indication.
Okay, that will be better.
Otherwise, this thing.
in the meantime, my lord, the condonation can be allowed if lordship chooses.
No, he has filed. He wanted to be heard on the condonation. That will be heard. That's a different issue altogether. The court will look into the merits of the application. But in the meantime, if you can trash out the problem or issue, whatever the case may be, then you don't need to go through this whole exercise.
Yes, ma'am. If I can request the claimant to discuss with my senior to discuss with the claimant,
exactly,
and come back with a figure beyond which they will not reduce.
Yes.
Then I can talk to the company.
You see, Mr. Hajarika, everything has to be reasonable.
Okay, my lord.
That should be the key word.
Yes, my lord.
Reasonable. Not that you like they used to call it. It should not be a windfall for you.
Yes.
Neither should be a loss for you. You have suffered. You decide to be, compensated for that.
We are suffering from
you're quite to be compensated for that.
11 years ago.
Today is.
Yes, 26, my lord.
We'll fix it on the 5th then.
Yes, my lord. Okay.
Before that,
yes.
I hope things are settled.
Okay, my lord. We will discuss.
I'll not record anything.
Yes. No, it is about value, so we will discuss and convey the thing to Honorable Court. Mr.
H. Hajarika, Learned Counsel for the respondent, has submitted that the objection to the application seeking condonation of delay filed by the applicant appellant has been filed before this court. On submission made with the parties, this matter is now posted for hearing on 5th.
Item number 5.
May I please, Your Lordship, some more time to file the affidavit of service, Lordship, for respondent number 5 and 6, Lordship.
You have amended your petition.
Yes, Lordship.
Now you have impugned the termination order. This is the case of that
that is
school
the case.
teacher.
Matter was finally heard.
Yes,
then subsequently,
who has contested election.
Yes, this is the matter.
Because eventually she was removed.
Yes.
That is termed as a termination.
My lord, because our prayer was that this matter is already infructuous. Then, my lord, this honorable court had allowed the permission to amend.
Yeah,
so, my lord, I am also not sure, my lord, whether amended.
We amended petition, we filed already, Lordship, then respondents is not yet received. That once again we just submit.
And my lord, the private response, the managing committee was earlier being represented by S. Bhattacharya, my lord. Now she is no longer representing this. So they will have to take fresh steps.
We already took steps, Lordship, but not received by.
Not received, or you have the service report claims that they have not received.
Yes, Lordship.
Refuse or not? You see, one thing is there. Either it has been refused, so they have not received, or the address is wrong. It has come back.
Better they find out the status.
We will find out, Lordship. We didn't.
She's also not sure.
Not
so,
sure, Lordship.
Let her find out the status. In fact, my lord, this matter may come up after the vacation also.
After vacation?
Okay, Lordship.
Ms. Learned Counsel for the petitioner has submitted that the notice issued upon the respondent number 5 and 6 that the report on the notice issued upon the respondent number 5 and 6 has not yet been received. The learned counsel would submit that.
ID card is.
You 5 and 6, ni?
Yes, Lordship.
Oh, ID card has been received.
Okay.
So, you see, when it comes to matters of this kind, where report or notice issued is received or yet to be received, it would be good, at least for you to learn that when you come to court, check the records.
Verify.
Because here we usually have the petition and the affidavit file, but the office record, office note would always be there in a separate correspondent file. So you check and see. Bench, the court master would be glad to help you, to assist you.
Okay, Lordship.
Otherwise, now you've come with now you say that report has not come, but here, if she had not shown it to me, I would have,
Yes.
agreed to your submission. So it's better check.
My
And
lord,
see.
if that is so, my lord, then the
Then
matter may come
we'll-
up for after vacation and
we'll
for
wait-
the appearance of the.
We'll wait for the appearance of the.
Yes, my lord.
Change now, to. Mr. Learned Counsel for the petitioner has submitted that the office record would show that the ID card, as far as the notice issued upon the respondent 5 and 6, have returned to the court with a which would indicate that the same have been that the said notice have been duly served upon such respondents. It is also prayed that since the said respondents have not yet appeared for this court, this matter may be adjourned for the day to allow the said respondents to make their appearance before this court. You are appearing for?
And for the state, my lord, respondent 1, 2, 3.
Mr. K.P. Vatsaji, Learned Counsel, Learned G, is present on
Yes,
behalf
my
of the
lord, 1,
respondent.
2, 4, my lord.
Respondent number 1, 2,
4.
3 and 4 respectively. State, so on behalf of the state respondent 1, 2, 3, 4.
Yes,
As prayed for, this is matter of the application.
obliged, my lord.
Item number 6.
Ayat ko ikalign ito. Accordingly, the notice upon the respondent number 5 and 6 is deemed to have been served.
Obliged, my lord.
Item number 6.
Yes. Yes, Mr. Jha.
Ma'am,
What are your instructions?
my lord, instruction is that we should, DPC is important, and we should, in absence of they are not providing the copy, we will proceed with the hearing. That will be it will be up to this honorable court to peruse or whatever it is. We'll proceed with that.
You start.
Your Lordship, if I may pray for some accommodation, Dr. Mozika is not here. He's on legs before court number 4. So
No, he can start.
My lord, that was instruction we got, that he was not keeping, Mr. Mojka was not, he said that we will do on the next day. I said okay.
So you're not prepared to be heard.
My lord, that was the instruction we.
Out of vacation. On pre made by the parties, this is matter of the vacation.
much pledged.
Item number 9.
May I please, Your Lordship. Lordship remembers this matter where the rest of the issues were already adjudicated. Only with regard to the
Calculation.
interest.
Is it on the calculation?
Yeah, calculation part we accepted. Whatever the calculation part was there from the part of the respondent, we accepted that, and what amount they have paid, we accepted that as well. Now the only issue that was left was that we were claiming the interest on that part, the amount which they have given us. So that Your Lordship was Your Lordship had asked me to provide some judgment so that I'm eligible for claiming the interest part on the area of the pension. So I have 3 judgment, Your Lordship. I'm relying. Based on this, Your Lordship may dispose of the matter, Your Lordship, because the rest of the.
No, we'll have to hear Mr. Debnath.
Yes, Your
not here.
Because what we were claiming was that only the interest part. Otherwise, what amount they have provided us after filing of the instant rate, we didn't deny that. We accepted the calculation as well. But having said that, the area almost after 2012-13, so after almost 10 years,
excuse me. Yes.
After denying me for 10 years of that pensionary benefits, they have paid me. And it was not that I was silent on that. There were a number of representation that was filed from the petitioner end, claiming those pensionary benefits. But it was denied. Not just denied, Your Lordship, rather the respondent authority to an extent claimed that they don't have the service records of the respondent as well, or petitioner as well. So for those reasons, ultimately I had to come before Your Lordship. Then after filing of the instant rate, immediately the respondent authority got the entire service record and they gave all this calculation, and then they paid that 1,96,000. So we didn't deny, we accepted that amount as well. But end of the day, what we expected was that that amount should have been come together with the interest. So all those 10 years which the respondent authority failed to pay us the pensionary benefits, that has to be come with some interest, Your Lordship. So that's only my.
So tell me, you are citing some. What is the?
Your Lordship, I have highlighted.
What is your reference here?
Lordship, I have highlighted all the relevant paras in those judgments.
Yes. Please point out.
Lordship.
Mr. Debnath is again not here.
Your Lordship, I'm supposed to provide that judgment to Debnath also. Let it come after vacation, Your Lordship. Then in that case, I'll provide those judgments also, and we'll have final argument.
This matter is like playing hide and seek between the parties.
Yes,
Last occasion you were not here.
I was not
Mr.
there.
Debnath was
Yes,
here.
sir.
Now you are here. He is not here. Mr. A. Joshi, Learned Counsel for Petition, is present. However, the respondent is not represented today. Accordingly, on prayer made by the Learned Counsel for the petitioner, this matter is now posted to be heard after the vacation. List accordingly.
Deeply obliged.
Not yet.
I just inquired. They're entering it in the computer. Maybe
So
5 10.
that will take time.
Your Honor also has DB division bench.
First, we have DB.
Yes, Your Lordship. Perhaps if Your Honor can accommodate me after DB.
What? Just tell me, what is the case about?
Yes, Your Lordship.
Thank you, Mr. Joshi. I think that's so.
Your Lordship, this criminal misapplication arises from a bail application. Your Honor was pleased to grant the accused 2 months interim bail in bail application number 32/2024. whereby Your Honor allowed him to go to Vellore CMC for treatment. Thereafter,
okay.
Your Lordship, after release, the accused went to the civil hospital. They reviewed him again, and he also intimated, then his family intimated, they are short of finances to do the same. Thereafter, his case was referred to the DHS, the Directorate of Health Services, for reimbursement of 2 lakh rupees in order to enable him to go for treatment. And Your Lordship, I've annexed that paper as well as Annexure 1. Annexure 1 is the order, I still remember, the order passed by your good self, Your Lordship. Second annexure is the referral made by the civil hospital to the DHS. Third annexure, Your Lordship, is a status report which says that the sanction is still pending. So on account of that, Your Lordship, I have cited for extension of the interim bail, and also on account of the deteriorating psychological health of the accused. Because, Your Lordship, if you remember, I don't know if you would, of course it's difficult, but when I made the submissions, I'd also brought to the court's notice that he suffers from major depressive disorder, and it has started to aggravate it in some sort. And the last medical report, again, Your Lordship, suggested that he needs family support as well to prevent further deterioration. And Your Lordship, it is also pertinent for me to mention herein that Your Honor had allowed him to go to Vellore for treatment of ulcerative colitis, not for major depressive disorder. And the attending doctor had also opined that he needs to be on a strict diet until, well, he gets operated, etc., etc. So on these supervening circumstances, Your Lordship, which are not under my control, I've sought for extension of interim bail.
So it means that he has not yet been treated as such.
No, Your Lordship, and it is not.
Sorry, my lord.
Yes, he's not been treated, Your Lordship, and it is all genuine. I'll tell why, Your Lordship. It is because after release, we went to the civil hospital. Therein, we were asked to go to Vellore, and we said we are not capable of affording that expense, and our case was referred to DHS. But the sanction is still awaited. I've annexed all relevant documents, Your Lordship. I believe it is reached as well.
What is your prayer now?
Sir, for extension of the interim bail.
Extension for what?
So in order to get himself treated, of course.
No, but you said he is not able to. He's not. He cannot afford to go to Vellore.
So I'll just take you to Annexure 1 for that purpose. It's already been approved. It's already been approved. All we await is the sanction. So is it before yourself, Your Lordship?
Yes.
Let me do it properly.
Annexure
Your Lordship, let me take you to the operating part of the judgment, which is at page 23. Page 23. The bail order, Your Lordship. It's at page 23, paragraph 20. Paragraph 20. Accordingly, on the ground of sickness and requirement of medical treatment, this court would grant interim bail to the accused son of the petitioner only for the purpose of allowing him to go to medical treatment at CMC, Vellore, in the state of Tamil Nadu. Consequently, the son of the accused is hereby directed to be released on interim bail for a period of 60 days. Your Lordship, and I'll take you to condition number 4, which says he shall report to the Superintendent, District Prisons and Correctional Home, Riboy, on 27th. Today is the 26th, Your Lordship. So on account of allowing him to go to Vellore, Your Honor had given him bail. Your Honor, let me take you to page 26,
Yes.
wherein my case was referred to the DHS for grant of financial assistance. The very last paragraph, an advance of 2 lakh is required to enable him to proceed to the above hospital, and the below portion, Your Lordship, referred to DHS for approval. Then Annexure 3, Your Lordship, which is at page 27, is a letter communicated to the mother of the accused person, the petitioner herein, wherein it was said
Yes.
that basically that your case has been approved, etc., please await sanction. Then, Your Lordship, after a few days went by, we went to the DHS office, and they gave us a printout, which is at page 28. Annexure 4, page 28, Annexure 4. As you can see, Your Lordship, from the entries made therein, date 18, kind approval, date 21, kind perusal, date 23, approval for the treatment may kindly be processed. So it has been processed, Your Lordship, and 25, approved. And lastly, sir, the date at 19, the entry at date number 19 says submitted for necessary sanction, please. So that is all we are waiting for, Your Lordship. Once we get that money, we would love to go to Vellore, of course. And Your Lordship, in between all of this, it's also incumbent upon myself to bring out that the accused is not well. He is not well at all. I'll take you to Annexure 5. Now, this Annexure 5 is a medical report which I had already placed before the Honorable Court when I moved the bail application. if I'll take you to, let me take you to page 30, Your Lordship. This medical report is from the time he was in custody. Page 30. As patient is still having suicidal ideation, so patient needs strong family support to prevent further deterioration. This is his history, Your Lordship. Thereafter, after release, he was again taken to civil hospital by his family, and he was taken on the 7th of October 2024. The medical report is placed at page number 31. The last lines, Your Lordship. Doctor is still giving the same opinion. He says, patient 31, Your Lordship. This is after release. So we go for reviews as a preserver. So this is a document from that time. The last paragraph, Your Lordship. Page 31, last paragraph. Patient still needs strong family support to prevent further deterioration as patient still having suicidal ideation. Thereafter, again he visited, Your Lordship, on the 30th of October 2022. The same opinion was given again at the very end, at page number 32. Patient needs regular medication and regular checkup. Patient needs strong family support to prevent further deterioration as he has suicidal ideations. And annexure 8, Your Lordship, is with regards to the ulcerative colitis. Because he kept going for reviews, he was not keeping well. And the doctor therein had said at the very end, Your Lordship, needs home-cooked meal on a strict diet. So until this is done, he needs to be on a strict diet as well. So on account of these supervening circumstances, Your Lordship, beyond my control, I humbly pray for his interim bail to be extended. That is my only prayer, Your Lordship. And also, Your Lordship, it is incumbent upon me to mention herein that while on interim bail, he appeared on all dates fixed before the Honorable Trial Court. I had made technical submissions, Your Lordship, but at the end, Your Honor was inclined to grant him bail on medical grounds alone.
Yes, Mr. Guru.
My lord, so far extension is concerned, my lord, I'll leave it to your lordship, my lord. But so far regular bail is concerned, my lord, I
think he has come today only for extension.
My lord, kindly the date of order, my lord. 26 September. And the date of first reporting is on 7th of the next month. So, my lord, while securing this 60 days time, my lord, the impression that was put before to your lordship was that it was a case of very serious nature, my lord. Now, kindly look into my lord, the behavior of the accused here, my lord. He was released on 26th. He reports after, my lord, almost 2 weeks. So, 2 weeks, my lord. It points to the fact that it is not very serious, my lord. Had it been very serious, immediately after the release, my lord would have reported before the concerned doctor. Waited for almost 14 days, my lord. The first reporting is on 7th. So, this shows that this indicates that, my lord,
Lordship, if you see the sequencing of the medical reports, is after every 14 days actually. So after his release, where the doctor said, please come, so he came. And on that particularly on the 7th, the intention was basically more in lines of telling them that Yes, we are available, but we are unable to go because of this circumstance, because the family had tried to arrange for finances. So 7th is basically a referral, sir. After that, if you see, it's after every 14 days. Whenever doctor calls, we go. It can be at the whims and fancies also, sir. So
See, this page 28.
28, sir.
This sanction was submitted for sanction. That is on 19th/11.
Yes.
So when was sanction accorded?
Yes, of course, sir. The letter says so. Page 27. Daniel C.M., son of such and such, is hereby allowed to undergo investigation treatment. Daniel C.M., son of such and such, is hereby allowed to undergo investigation treatment at Christian Medical College and at Vellore for ulcerative colitis as recommended by Civil Hospital, Laba. So it's already been approved, Your Lordship. We are awaiting sanction only as enshrined through Annexure 4, the last entry, which is date 19 November 2024.
My lord, if I may propose, my lord, if this matter comes up tomorrow, my lord, I have to go through, I was given the copy just now. There are a number of documents, I have to compare it, my lord, whether.
There's nothing much in this.
The
And
deadline
plus the
is tomorrow.
surrender date is tomorrow.
The deadline is tomorrow.
It is tomorrow.
So
And there's nothing much, sir.
tomorrow is to report.
My lord, tomorrow means any time of the day, my lord. So if it comes in the morning, first hour, I can assist the honorable court, my lord. Some comparison has to be done, my lord. Whether I don't have any objection for extension, my lord, provided that my lord's kindness should not be taken for a ride, my lord. That is what more concerned, my lord.
We have to look at these. The
Your
court,
Lordship,
see, the court would be conscious of the
Exactly.
Firstly, the medical report.
My lord.
Absolutely.
We cannot, you see, we cannot contradict whatever the
Exactly.
the doctor or medical experts have opined.
Exactly.
Or any of their findings cannot be contradicted. If,
in that
as far
case,
as the patient is concerned,
in that case,
the findings are very very clear.
Yes.
Yes, sir.
So, my
he
lord,
requires medical attention.
my lord.
True. And we also know, I mean, see, we are aware of the formalities
Exactly.
as far as the office is concerned for the sanction to be processed and so on and so forth. So finally, sanction has been accorded according to him. It is also understandable that perhaps he may not have adequate fund, which is required. So
Till then, till such time, my lord, since he cannot go for medical treatment, my lord, and he had been getting treatment from the jail itself all the time. So, my lord, what difference it will make, he being outside without any treatment? He is getting better treatment in the jail, my lord. Till such time when this approval is not given by the concerned department, it should be sent back to the jail, my lord.
Lordship, in view of that, I knew perhaps that would be raised. And that is why I've annexed also documents wherein the doctor said he needs the psychiatric versions. And that is not manufactured by me, because these are reports also dating back from the time he was in custody, which have actually said that he needs family support. And so it's a genuine case. I have actually laid down documents. Perhaps sending him to jail wouldn't be proper at this stage. All I ask is time.
Anyway, this court will grant you the extension.
Yes, Your Lordship.
And as Mr. Guru had said, it would, of course, the court would not impose on you, but it would be according to your wisdom. Your wisdom means the petitioner's wisdom as to whether to send the accused for treatment to Vellore or to get him treated locally.
So we're trying that. It's not working,
So
and
it's up to you.
yes, Your Lordship.
It's up to you. You get it.
We'll explore that as
And apart from that, no comments will be made, because you have not made any submission as regard the the opinion of the doctor with regard to his psychiatric or his psychological state of mind. If he is, if it is true that there's a suicidal tendency, then it would be dangerous to keep him confined. Also.
I have
But
brought
that
this.
would be another aspect of the matter.
Yes.
In the meantime, since you're getting the liberty of being outside
Yes, Your Lordship.
of custody for pursuing your treatment, medical treatment, you could also take the opportunity to get it treated by a psychiatrist or any other neurologist, whoever.
Absolutely. We are going to the doctor who's attending us before civil, and we will also consider other possibilities as well.
And get a and get a report on that.
Absolutely. We will explore other possibilities.
We have many competent hospitals, my lord, here in our state also.
True.
So,
We have, but if a reference made by a specialist, so we went by. Of course, we will make explore other possibilities as well.
Heard Mr. S. Yadav, learned counsel for the petitioner, who has submitted that this court by order dated 26/9/2024 in BA number 32 of 2024 had allowed the accused son of the petitioner named Daniel C.M. to be enlarged on interim bail to enable him to proceed for medical treatment at the CMC Vellore in the state of Tamil Nadu as recommended by the concerned doctor. It is the submission of the learned counsel that pursuant to this said order, the petitioner had taken steps to procure the necessary funds for the necessary funds towards the cost of treatment, etc., for which, as is entitled, she had approached the Director Health Services for sanction of such funds. It is also sanction of such fund. However, since the process of sanction had taken some time, the final order of sanction having been made on 19/11/2024, therefore the patient, the accused, could not proceed to for the said medical treatment in time, and at present is still in time. Now that the sanction has been accorded, the patient may be allowed to proceed to the said hospital for the necessary treatment. In the meantime, since the direction of this court by the said order dated 26/9/2024 supra, whereby the wherein the time allowed for such treatment would expire today, the petitioner has now approached this court seeking for the extension of the interim bail to allow the patient to be treated as proposed, as recommended. Mr. Argun Lanerji, appearing for the state respondent, has no strong objection to the prayer for extension of the interim bail for the said purpose. However, the Lanerji has also submitted that since there are adequate medical facilities And since there are proper medical institutions with adequate medical facilities available in the state of Meghalaya, the petitioner may be directed to avail any of such facilities within the state. This court has given due consideration to the submission made, and as far as the prayer made by the petitioner is concerned and the reasons given for the delay in proceeding for the said medical treatment, vis-a-vis the time frame allotted by this court, the court would allow the prayer made and the interim bail granted is hereby extended for the period of 2 months.
4 months, sir.
2 months from today.
So 3 months if.
3 months.
Yes, if it's all right.
We don't know what is the sometimes it might take, of course, velour may take some time. We may not.
So 3 if it's all right. I mean,
3 months. Remember, I'm giving you this leniency only, with on consideration of the other aspect of the matter, this psychological aspect, which, like I said, would not figure in the order.
Right.
But that is only. Otherwise, normally it would not have. Since you've been in custody for 1 year or so.
Yeah, I was. Yes.
Okay. It is next point. It is incumbent upon the petitioner to ensure that the accused person report to the prison authorities at the district prison and correctional home. This is Ribhoi, yeah?
Ribhoi.
Ribhoi district, Nongpo. Can we calculate the date from now?
Yes, my lord.
When will?
So, my lord, whether these 3 months will be effective from last order or from today?
From today.
From today. So, in that case, my lord.
26. 24.
26.
November, December, January, February. It will come to February, my lord.
26th February.
26th of February.
More or less.
My lord.
On 26th February 2025. With okay, since this petition will be disposed of, so calling for the status report would not be.
My lord. Then a report may be furnished, my lord, of reporting before, my lord. So the court will be aware whether.
That is why report will be furnished where?
True, because it's disposed.
If the petition is disposed of.
If need so be, so when I file any subsequent application, I would be filing it along with that reports in case, if at all it's required. That would be the right way.
Because keeping this pending for that many months would not be.
Because this was for the limited period. Prayer has been allowed, so no point keeping it pending.
Yeah, so I don't know. it is also directed that the petitioner would file a misapplication before this court with the said compliance report.
My lord.
I am bringing the said compliance report on record.
Yes.
Deeply obliged.
Highly
It shall
obliged.
dispose of.
Good day, Your Lordship.